number 28, the people of the state of New York versus Keith Brooks. Counsel?
Yeah, thank you. Paul Anderson for the people. May I reserve 2 minutes for
Yes, sir.
rebuttal?
2 minutes, you say?
Yes, please.
Yes.
Thank you. So I guess this case, well, the first case was more about the hearsay requirement. This case, I think, speaks more to the verification requirement. And I think Your Honors just touched upon that issue here of how are courts to treat people that we're not too sure can swear out a complaint because they didn't read it. It's not just English speakers. A blind complaining witness, an illiterate complaining witness, we would have these same issues. And these presumably were issues that were contemplated by the legislature when they came up with the scheme. And that's why I think in that 100.3 sub 2, if a court has any doubt as to the verification, the court can, in its discretion, say, you know what, I want a different method of verification. But the statute says it has to be one of the 5 under 130 sub 1. So there really isn't a provision for file this novel document. So this is distinguishable from cases with witnesses under 8 years old who have.
So just clarify for me, I may have misunderstood here. So I'm looking at the record, the supporting deposition of Carlos Ayala. Right? Mr. Ayala's, what he signed says that I have read the complaint, but that's not possible at all. That is obviously incorrect on its face. If you have another document that says, I, Violeta Sambula, translated the contents of the accusatory instrument for Mr. Ayala. I mean, on its face, it's incorrect, right?
Well, you could read and not understand. I could read a document in Spanish, and I don't speak Spanish, but I could read that.
But then it says, and that the facts stated in that complaint are true upon my personal knowledge. So it's just not possible, right?
Well, it would be possible if someone explained to him what was in that
But
complaint.
that's not what it says. I'm
Yeah.
talking about what it says. If it had said, I, Carlos Ayala, have been informed by Violeta Sambula as to the contents of that would be a different statement, but that's not what it says, right?
And that could be a question used in cross-examination at trial for credibility. You said you read this, or maybe a defense to perjury. If someone somehow charge him with perjury for claiming he read something he didn't. Well, actually, it was read to me. But
isn't this on its face? Can't I just look at this?
Excuse me, but
Isn't this on its face that I know? Isn't this within the 4 corners?
No, Your Honor, because the certificate of translation isn't part of the accusatory instrument. It's an unsworn document that's just buttressing, that lets defense counsel know and the court know a translator was used here.
So even though he makes a statement, which obviously is incorrect.
Well, yes, he
Right,
adopts
he's signing something that it's text. It's obviously incorrect. Doesn't that incentivize withholding certificates or not creating them at all?
Well, no, Your Honor. I would say...
Why not?
First of all, it wouldn't be on its face that it couldn't have happened because someone can use a translator who actually reads English but just is more comfortable to have a translator there and have it buttressed by another translation. So theoretically, there could be a defendant that has both, reads it in English and has it explained to them.
Yeah, but if I can interrupt you there, what your point was that they don't feel comfortable, they want something else. So again, they're not able to do it. But let's talk about the policy, the incentivizing. I think there's incentive for you all to do it right, but I'm asking you about the problem that I'm seeing on this record.
So you're saying that it's incentivizing us not to turn over or generate certificates at all?
I'm asking, it would, on its face, when we look at this and say, well, if you permit this, it disincentivizes having the certificate or submitting them along with the document. But I'm asking you what is the incentive the other way, or why isn't it a disincentive?
It's not a disincentive. Well, first of all, it seems like more of a discovery dispute down the line of what happened during the drafting of this complaint. What was anyone there?
No, but my point is, why isn't it an incentive to make it a discovery issue rather than an issue about the facial sufficiency of the instrument and its supporting documentation? So I'm just asking, where does the incentive work so that, again, we have everything that shows that Mr. Ayala understands what he's reading and that defendant can appreciate if indeed there's someone making a statement about them who doesn't speak English and or read English. It's possible, it's both.
Well, I think then that goes to the two purposes of discovery versus filing a criminal
Okay.
complaint or filing an information.
Okay.
This is a sworn statement saying this is the charges against you, here's how you can prepare a defense, and then discovery is everything that goes along with it. And now with the new CPL 245, which the broad discovery rules, I think nearly everything would be turned over. If, yes, a translator was there with a complaining witness, translating in Spanish, here you go, and then if we generated it and didn't turn it over or down the line forgot, I think the court could then decide either our certificate of compliance was wrong or figure out a prejudice analysis. But in terms of conversion, which is really what the issue is here, and I guess it would be in the new scheme 3035-A in terms of we have to certify that we're converted. This isn't a conversion issue. We have the statement of the actual complaining witness here, which matches to the complaint, reading the four corners of that. And yes, there was an
And it is
unsworn
fully
document.
in the control of the prosecutor, under your reading of statute, fully in control of the prosecutor to inform the defendant up front that this individual doesn't speak English and needed a translator.
Or that one was provided, yes.
Right, it's fully in control of the prosecutor to hold that, give it to them later in discovery.
Yes, Your Honor, it wouldn't affect conversion at all. I mean, and especially nowadays with, we have the 15 days to comply with our discovery requirements, it would be turned over there. Or if we have it and we can just give it to them right then in arraignments, why not just give it right there?
Why is that a good system? One in which someone can make, on its face, a statement that is incorrect, I'm not saying it's intentional,
Yeah.
is incorrect, and we allow the prosecution to proceed to some later stage. Why would we want that kind of system?
Well, once again, whether it's a good system or not, it's the system the legislature has decided for us. So whether we're deciding to add
Yeah,
extra
but
things.
you agreed with me that it's in the power of the prosecutor to avoid the problem. But you're saying we don't have to seek to avoid it, because the law doesn't require it.
Well, we try to avoid the problem, and we do our best to turn over things
Okay.
as we get it, and as we do. But to then say that we're required in order for conversion purposes rather than discovery to do this extra step that's outside the legislature is just beyond what anyone can foresee or contemplate, especially when we don't have any idea
So
what
if the legislature mandated it, which is what you see as the difference, it's not mandated by the CPL, so we don't have to do it that way, under the case law, this is sufficient, it's a latent defect at best, deal with it later. But if the legislature mandated something different, you're not saying that the DA's office wouldn't be able to comply.
Well, my office would probably be able to, but I can't imagine St. Lawrence County or Wyoming County, if that would be an issue for them.
Why not?
I don't wanna speak-
Why not?
I just don't know their resources in terms of like being able to how busy their complaint room is, how much they can turn over a complaint and get it notarized. Or if we go down if the legislature decides to follow the 2101B down the line, I'm not saying they would, I don't know how that would affect these other offices. I'm not a legislature, I don't know
But
how
it seems
they...
to work in the civil system. Why wouldn't it be appropriate for the criminal justice system where people's liberty is at issue and
Well,
in danger?
the civil system, you have accelerated judgment, and so there are that has to be evidence that's admissible. Here, the only rule of admissibility is facial hearsay, not anything else, not best evidence rule, none of those. So the legislature has made the sound decision, or their decision that I can't argue, or I can't fight that they made the decision of here's how you go forward with a
Chief,
prosecution.
there's just one thing I'd like to explore if I
Yes,
could.
Judge Wilson?
So I want to ask about incentives a little bit differently. Your answer to my earlier question, basically that you could put off the cross-examination of the complainant until trial, and if it turned out there was a mistranslation or it had never been shown to the witness or so on, that could come out of trial, could go to credibility. That made me think that perhaps your office would have a pretty strong incentive to do the translations correctly and to prepare a certificate of translation of some sort at the time the instrument was, not the instrument, but the declaration was sworn to avoid that kind of, or at least mitigate that kind of cross-examination. Is that right? That is, let me ask it differently. If we adopt the position that you're advocating, which is that it's just the facial sufficiency that matters, my assumption is you would go on trying to do the translations as best as you could and documenting that. Is that wrong or right?
I believe, yeah, we'd make sure to do that, because we're still not sure how 245 would treat these certificates. I don't think any court has addressed that yet. But yeah, I think we would still try to memorialize these translations, but then trying to figure out what form or what that is just up in the air, and we wouldn't be able to look at the statute to kind of figure it out unless we go the route of the court in this case, which looked at an administrative court rule and kind of backdoored in select provisions of 2101 without reading it all together. I mean, I think that was like really the issue here. And yes, our office makes these and files these, and I think many offices do because of all of the extant case law in the lower courts, in criminal courts. I think only very recently, I think Hernandez might have been the first case in the appellate term second department, which really brought these up to the intermediate appellate level of like, oh, these certificates of translation, what's their role in all this?
Yeah, I mean, I guess I'm asking, even if you had no obligation to ever file these or even produce them perhaps, you might still do them to protect your witnesses at trial.
I mean, it would be, yes, Your Honor, it would be good practice to at least have it in our file that a translator was used and then turn
Who the
that over,
translator
'cause why
was, and
not?
it was, yeah. Right.
But then we go into, what's the minimum floor for the qualifications of the translator? This officer who took the statement down, he spoke it from when he was 10 and on. I don't know. We
Right.
could get lost in all of that litigation, which I think is important that the legislature tried to avoid, and making these pretrial requirements that we just look at the face of the instrument. You have the person who's the source of the information, signing it right there, facially verified under 100.30, under penalty of perjury, or any of the other methods. And if a court has an issue with it, the court can, under sub 2, ask the prosecutor to go any of the different ways, but once again, any of those ways that are outlined in the statute are specifically delineated. And so that's what we have to look at. And this court in Hardy and in People v. Anonymous, we don't really look, when the legislature is quiet, they are quiet for a reason. They didn't contemplate a separate situation, or it's really not us to, I guess, legislate under the guise of interpretation, as this court said in Finnegan.
Thank you,
So for these
counsel.
reasons, I ask
Thank
you
you,
to-
counsel. Counsel? Ms. Isaacs?
Good afternoon, Your Honors. Elizabeth Isaacs for Respondent Keith Brooks. This case is fundamentally about verification, or swearing a testimonial oath. And where a court cannot be assured that the person who took that oath understood it, it causes apparent problems in the process. And the verification requirement really isn't met. I think it's helpful to look at the scenario where a complainant comes into court to verify a complaint, which is, of course, one of the options under 100.30. And I don't think there's any question that a court can and should employ the services of an interpreter if the complainant verifying in person is unable to do so in English because their native language is a different language. So if Mr. Ayala had come in to verify the complaint in person, there would be no doubt that an interpreter would be used. It would be someone whose qualifications are known to the court, and someone who does so under oath of the accuracy of the translation. What happened here is really no different. The requirement imposed is simply that the same verification standard be met for one that happens outside of court. We don't need to have the CPL dictate to the trial court exactly how to use an interpreter for an in-court verification. That is well within the province of the court to shape, and that's exactly what happened here, where the trial court looked for guidance to a provision of the CPLR that deals with an analogous scenario and drew guidance from it. Said this should be a sworn document. This should be something where the person attests to the accuracy and where we know something about their ability to translate. We submit that those are three reasonable, those are three requirements that are very simple. They're easy to follow.
Counsel, this is Judge Rivera. But if the CPL sets out the requirements, why is a judge able to go look beyond that statute and decide for him or herself what might be the better way to get this done? Why isn't counsel right? That's for the legislature. If there's a problem, The legislature, if the legislature determines, this really is a problem, we should address it, let's find a way to address it, isn't that the proper form and the proper way to do that?
I would say that the court looked outside the CPL for the particulars of what could be required for the affidavit of translation. The court did not look outside the CPL for the verification requirement, which needs to ensure that the complainant here, Mr. Ayala, could understand the allegations and the statement about verifying them under penalty of perjury. Without that, the court was put on notice that, at the stage of conversion, that there was a defect here. And if the court was supposed to simply overlook that, that's certainly not what the CPL
Counsel,
contemplates.
this is Judge Stein. Aren't you presuming a defect? Aren't there any number of circumstances in which someone may have provided a translation for better comfort or whatever, but where the person did in fact understand? Maybe it's not a non-English speaking person, maybe it's an illiterate person, maybe, could be a lot of different things. So why would we presume that it was not a proper verification, rather than looking at the document, saying it was signed, it said, I swore, I understand, that's what the facts are accurate and true, and all that stuff. And then if there's a question about it, that goes to, as your adversary has said, discovery or trial, cross-examination. What's the problem with that?
I think the problem is that here the court was, the certificate that was filed was inextricably linked with the supporting deposition that was submitted. It was submitted at the time that the prosecution was converting. And so the court was was basically informed that a translator was needed for this complainant to verify the document. At that point, there's a question about whether the verification was legitimate. It was entirely reasonable for the court to, require, the qualifications of the person for it to be sworn, because of course, most misdemeanors, the vast majority are not going to a fact-finding stage. And so they're ending in a plea. This is an incredibly crucial safeguard. The verification requirement is vital to making sure that people are not being prosecuted on unsupported instruments. And to speak to something that was raised earlier about the kind of equity concerns here, I think that complainants, informants that do not speak English, as a first language or well enough to verify the document in English, it's very important that the system supports processes that allow their stories to be heard, their voices to be heard as they report crimes. I think that the principles of equity here actually are very much in the favor of requiring an affidavit of translation in these circumstances. And it's not a heavy lift. As we know, this is already being done in the majority of cases. If the question is precisely the best way to do it, again, I think the parallel is to the trial court who receives the verification in person. The court is not required to, follow the letter of a statute to decide to employ, a court interpreter who is qualified. We leave that to the judiciary to decide, the best way to afford an interpreter. This is exactly like what happened here. It was simply done for purposes of an out-of-court verification to ensure that the same accuracy of translation is present.
Judge, could I ask?
Judge Fahey.
Thank you. I just want to turn to a different issue for a second. On this decision, the court relied on 2101B and of the CPLR. And what I'm wondering is if we should agree with your argument and uphold the court's decision, would we be saying that the whole of the CPLR is now applicable to criminal cases and can be applied at any point. I think he relied on the rules in 200.3. In other words, can the CPLR, now if we rule the way you've asked and uphold it, are we saying the CPLR can be applied at any point in the criminal procedure law?
No, Your Honor, I don't think that that
okay,
would
let me
be,
stop you.
that broader ruling would be necessary.
Well, why not? Why if we're allowing it here, why wouldn't we be allowing it anywhere else?
I think that the best way to read what the lower court did, and specifically looking at the language of the trial court decision, is that in the absence of a specific CPL provision that addressed what an affidavit of translation contains, the court looked by analogy to 2101B for guidance, which, you know, is completely permissible. It does not mean that the court was reading in a new facial sufficiency requirement under the CPL. It was merely trying to effectuate the purpose of the verification requirement.
So you're saying that the court looked at it in the way this court would look at a ruling from another state to draw on their legal reasoning to support something that we want to do here. Are you drawing that kind of analogy?
I think that the court did indicate that the uniform rules of courts require, you know, the application of 2101. But in the language of the trial court decision, it does say that based on the foregoing, where it's described 2101B, it stands to reason that if a paper served or filed in the English language was translated into a foreign language so that the complainant could understand its contents, then it should be accompanied by an affidavit of translation. So I think that same analogy is that the court was not holding that the CPL, all of CPLR 2101B, CPLR 2101.
Let me stop you for a second. That's not the way I read it. The way I read it is he relied on the authority to do this based on 2101B. You're saying that isn't correct, or you're saying that that's what he relied on? That's the way I read his decision. That he relied on the authority to do this on 2101B. And he correctly quoted the rules. My question is twofold. If he can do it there to 2101B, are we now allowing the entire CPLR to be subsumed into criminal procedure law whenever the trial court decides it can or needs to? And you're saying...
No,
I understand that, and you gave an intellectually honest answer, which I appreciate. I pointed out to you, but the problem is I don't see what limiting factor there is that would limit it to this circumstance.
I think that here it is that the CPL does not directly address what should be the best kind of proof for accuracy of a translation.
Well,
and so it was cited by analogy.
Counselor, the CPL does address the methods that the court may take if it's not satisfied with the verification. So isn't this going beyond that statute?
I understand your question, and this goes to one of the key arguments that my adversary makes. I think that the mistake there is that the court here was simply effectuating the out-of-court verification requirement that is allowed in the statute. So this is not creating a new one, in the same way that one of the ways a complainant can verify is in person. And again, the statute does not address what happens when that complainant comes into court to verify and the person is a Spanish speaker alone. So in that scenario, a court is surely free to call on a court interpreter, make sure that person is qualified, And so in the same way here, it was completely permissible to require more assurances of the accuracy of the translation. And
Counsel,
frankly,
counsel,
the court...
If the Chief Judge will permit me, because your light is off, it'll be my last question to you. The difficulty I'm having, beyond some of the difficulty you hear, I think, the bench with this argument, is that 2101B, what it really is anticipating is the affidavit is in a foreign language, and then it is translated. Here, you never have the original affidavit in the foreign language. You don't have a complainant or a witness being asked to prepare an affidavit in their language, the language that they speak, or they write, or they can read, whatever the language is, their primary language. And that's the problem, that 2101B in that way is not really applicable to this scenario, which is a question I asked in the prior case about sort of that process. So that's, I think, a challenge you have with this. Can you address how this can apply when it's really intended to apply to a different scenario?
Absolutely, and I think that it's true that 2101B on its face addresses the, what to do if a document is submitted, filed in court in a foreign language. But as Your Honor, Judge Rivera, you addressed earlier on, that the complainant's report here is being given in another language. So I think the animating purpose, the policy behind 2101B, which is what the court below, the trial court was looking at, is exactly the same, to assure the court that where a process as important as verification is in the misdemeanor context, when we are relying on a verification that has been translated, the court needs an assurance that it has been properly done by a qualified person. It's a very low bar. I mean, I think that requiring someone to list their qualifications and to state that it's accurate in a sworn document is simply a clarifying rule, and one that would actually assist, I think, all the parties involved. And in terms of, I'm sorry, my light is off, so I'll ask Your Honor if there's any further questions.
No further questions. Thank you, counsel. Counsel?
Yes, thank you.
Thank you.
Just to briefly respond to the lower court's analysis, it's laid it out step by step. The court looked at Rule 200.3, and based on 200.3, which says, you look at the applicable provisions of 2101 for documents filed in criminal court, and then looked at 2101 and found this that said documents filed in a foreign language. But then that's where the court said stands to reason if a paper is served the other way in English, as Judge Rivera was pointing out. That was the leap in analogy the court made. And that is a question that I don't know if this court needs to decide it in a drunk driving prosecution, considering the amount of civil cases this would probably affect, is not really a question that the CPL or the legislature really wanted to inject in these criminal prosecutions. And once again, as I've argued, Rule 200.3 applying this way, an administrative court rule to legislate, essentially, that we look at 2101 is unconstitutional. And if Your Honors have no questions, I'll ask that you reverse.
Thank you, counsel.